That is a great question. So folks that are tuning in from their computers that tune in will be able to put questions in the chat. And then folks that tune in from a screen will be able to, well, I suppose also throw questions in the chat.
Okay, and you'll be able to read them to me or something? Or is it going to be in this chat?
Yes.
Okay, unmuted. Okay. Okay. Okay.
Okay, and we are recording.
Okay. So, are we ready to go?
I think we're ready to go.
Okay. Well, hello, everyone. Thanks for having me, and I'm really excited to be here. So, welcome to Esports and Video Game Law, a lecture featuring a look at contract and name, image, and likeness matters for professional gamers, streamers, and content creators. First, I'll start by introducing myself, and then we'll kind of go into today's lecture. So, I'm Justin Jacobson. I'm an esports, video game, and entertainment attorney based in New York City. For the last decade, I've handled all legal and business matters for professional athletes, musicians, DJs, fashion designers, producers, professional gamers, streamers, coaches, casters, esports teams, video game companies, and other individuals in the space. I also teach esports and video game business courses at University of North Carolina, Wilmington, at Post University in Connecticut, and at Harrisburg University. I'm also a professor at CUNY Hunter College, where I teach media law, as well as teaching sports law at Manhattanville College in New York. Finally, I've authored The Essential Guide to the Business and Law of Esports and Professional Video Gaming, which is the first textbook on the legal and business side of esports and professional video gaming world. So before we start, if anybody has any questions on the lecture or myself, please, ask me directly in the chat, or you can reach out to me via email. It's in the chat. It's justin@jmjesq.com. I'm happy to answer any questions, or you can find me on LinkedIn, Justin M. Jacobson, or on Twitter, Justin JESQ. So before we start, just as a disclaimer, nothing here is intended as legal advice, as all the information is for educational purposes only. And just to get an idea, if you have specific questions about your own situation that you may ask, we're going to try to not have it that poignant. We're going to try to give general questions and general answers so that's more applicable to everybody. And if you do have a specific question about your own situation, it's definitely more appropriate to, reach out on the side or after so that that can be, talked about properly. Great. So, as I mentioned today, we're going to explore several matters related to professional gamers, streamers, and content creator contracts, including matters related to their name, image, and likeness, their NIL rights. So first, we're going to start at look at some common contract clauses, including many professional gamer, streamer, and content creator agreements with professional esports teams and organizations. It's important to be aware that every deal is different. And this lecture is really intended to focus on and explain some of the most important and prevalent ones. Obviously, these agreements are, 20, 30, or 40 pages, so they're not going to be all the same, but there's a certain pattern, a certain vernacular, a certain kind of almost standard provisions that are in most tier 1 and tier 2 and orgs and major games that are playing across the world. So to first start, we'll look at, a contract provision that's in every agreement, which is the term. So the term of the deal, which is the length of the agreement, how long it's actually going to last for. So in esports, this could be for a month, several months, a 6-month time period, or a year or multiple year deal, or even it might just last for one tournament or one league season or any other time frame that the parties agree to. So it's really unique in that a contract with a team or organization could be fashioned for just that one season or just one tournament. And if you don't do well, or you don't get a certain result, the contract could end. Their term also might include information on any options, which are, the ability to renew or extend an existing contract, and it'll also list how many options. It could be a 1-year deal with 2 more options, meaning it could be a 1+2, which is a potential 3-year deal, or it could be longer, or it could be shorter. And all this stuff is agreed to and explained in these agreements. Generally, it also addresses who has the right to extend it. It might be just one party, such as the team having the right to continue, or it might be on mutual agreement of both parties. So these are really important things because having the right to extend and continue the contract can determine a talent's future, whether they're becoming a free agent now or in another time period. So another really important clause, and I'm sure most people are really interested in this one, is ones that address the compensation that the gaming talent receives. So many gaming players, whether it's creators, streamers, or competitive players, when they're signed to an esports team, they may receive a salary, and the amount that they receive is, varies substantially. And it could be paid monthly or any other increments that are agreed to. It could be paid per content piece or however many hours if you stream a month. So there's lots of different variations that go into it. And the amount that can be earned could be hundreds a month, thousands a month, or more, where there are actually certain leagues such as the Call of Duty League and Overwatch League, which have mandated minimum yearly salaries where a player cannot make less than this amount. They can certainly make more, but it kind of creates a floor for how much they're going to get paid to compete. So agreements also address whether you have any salary increases as you go through the term, whether it's, year 1 is a certain rate and then it gets higher and your salary is raised in year 2 or year 3. These are things that you would agree to. Additionally, there might be information, and for most competitive players who compete in tournaments and leagues and different events, a team might usually be entitled to a percentage of these winnings. The amount that they get varies substantially from as little as 5 to 10% or 15 to 20, or sometimes there's been reports of higher, but ultimately it's important to be aware that if a competitive player is competing for a team, a percentage of their tournament winnings, league winnings, anything that they earn competing, the team might get a percentage of this. Additionally, most creators and streamers earn income through the actual use of streaming and social media platforms. So this could be, using Twitch or YouTube gaming, and you might have subs or subscribers and different platform currencies such as tips and bits and stars and all these digital currencies that a creator or a streamer might earn income from. So similar to a salary and the tournament winnings, a team might be entitled to a percentage of this income. So it's obviously something very important, and it's pretty common in the industry for a streamer or creator to be entitled to 100% in all of their earnings from these platforms, but sometimes it changes. So it's really important to know that these different streams of income, a team might be contractually obligated and entitled to a percentage of them. This also might apply to any advertising income that might be earned from ads on the stream or on any created content on TikTok or Instagram or YouTube or any of these other social media platforms where you are getting advertising revenue. So again, depending on how your contract is structured, the team might get a percentage of this, or they might not, or they might get a percentage of deals that they secure related to the use of your social media. So all these things are really important to be aware of, as they have real huge implications. If you have hundreds or thousands of dollars in social media income, and now the company or the team that you're signed to gets a percentage of it, that could be a large sum of money. It might even be more than they're paying you as your salary. So in addition to the ability to earn income through streaming and salary, there's actually opportunities in many competitive titles for players to actually earn a percentage of income from any in-game transactions. So from the sale of any digital items, either featuring the team themselves, so their logos, their team name, colors, or featuring the gamer themselves. So sometimes an actual gamer will be displayed on an in-game item, such as a weapons kit or skins or any other in-game consumable. So generally your contract will address whether a player or a creator gets a cut of this percentage that's earned from the sale of these items or not. Sometimes there might be certain percentage where you get a larger percentage if you're featured in it versus just team items. So these are all really important because some of these digital items sell hundreds of thousands, if not millions of dollars. And to get a cut of that is pretty substantial as a creator or competitive gamer. Similarly, some players might get a cut of actual physical and digital merchandise. So not just the in-game items. There might be what's called team branded merchandise, which is what it sounds like, any merch, whether it's hoodies, hats, t-shirts, anything that has the team logo or name. And then player branded merchandise, whether it's jerseys or hats or t-shirts or any physical or digital item that has a specific player on it or their name, image, and likeness that we learn about and talk about so much and we'll really address at the end of the lecture. There might be opportunities to get a percentage of any digital items, NFTs, digital consumables, digital player cards, digital collectibles. So these are all things that are addressed in the agreement and that all talent should be aware of when they're signing deals of what these percentages are because you're incentivized. If there's a skin that features you or your team and you get a percentage of it, then you're probably going to tell your fans, hey, go check it out, go support me. And it's important to be aware of that as this is a business decision. You need to operate like that. In addition to salary and any other income that a competitive gamer or streamer or content creator might earn, an esports team may actually cover their living and other day-to-day expenses such as rent and electricity and cable and other utilities. If their players are living at a gaming or content house or during boot camps or any of these mandated events, they might cover the costs for transportation and hotels for different events, tournaments, as well as potential visas and work authorization and anything else needed to fulfill their obligations on behalf of the team. This all will hopefully be covered by the team and it'll be addressed in the agreement so that you know what's covered and what's not. And these are things that might be really important. If you have to move to a different state or a different country, there might be the ability to get moving fees and have this stuff agreed to so that those costs are bared by the team or the organization and not the talent. Because if it's not addressed in the agreement, it's probably not going to be covered. And it's definitely not going to be mandated to be covered. So it's important to be aware that if you have to incur expenses to do a promotional opportunity or a sponsorship or any of these other things on behalf of the team, it should hopefully be covered and reimbursed by them. Or something in the agreement says that it's at the team's cost or the organization's sole cost. So if there is a cost to do it, they'll cover it. Some teams may actually either provide you or cover the cost for any equipment. So if they're going to give you, new PCs or a new console or anything else to compete with and practice with, they may cover it. It may be provided by their sponsors, but they're not necessarily going to charge you for a new mouse or keyboard. Then again, they might. So it's important to be aware of what you're provided and how it's covered. There's also opportunities, and we started to see this trend of organizations providing personal trainers and health and wellness coaches and sports psychologists and nutritionists and even team chefs to really help their talent and help them really kind of with their performances and their ability to grow and handle some of the pressures that go on with this. So again, these kind of ideas would be covered, whether they're providing these at their cost, whether they're giving the ability to use these things. It's all important to be agreed in writing because if it's not in writing, it's really up to whether the team or the other company wants to, adhere to it and listen to it, which, as we know, isn't always the easiest thing. And as we see in today's economy, if it's not in writing, I don't know if teams are going to cover things, with people getting fired all the time. So again, the idea is that you want to be protected and you want to know what's covered and what's not covered and what might need to be covered. Additionally, many different contracts have restrictions and kind of address how a player may have an independent sponsorship. So sponsorship or endorsement just for that specific player that's not necessarily applicable to the team. And generally, this is really important for streamers and content creators and, competitive gamers to sometimes a lesser extent, where knowing what brands you can and cannot work with, what the deals can look like, whether you need approval from the team, whether you can have a competitor of their existing sponsor or not, whether you can have a competitor or existing sponsor and something they're carving out and saying, hey, we don't have a sponsor here now, but we might, so you can't get a competitor here, or you have to ask our permission before you do that. Additionally, there might be an opportunity for the team or organization to get a percentage of deals they bring you. Whereas if they're able to secure you, the player, the talent, the streamer, an independent endorsement deal or paid post or activation, they may take a percentage of that. And I think a key thing is to see whether that's a non-exclusive or an exclusive arrangement, as we saw with some of the issues early on with the Tfue and FaZe Class situation. It's important to be aware that most of the time they should be your non-exclusive, sponsorship and have the ability to maybe go out, but not be the only party on your behalf. So this is a really important distinction that, most talent should be aware of, especially if you have other individuals, whether it's agents, managers, attorneys, representatives, anyone else that's also out there trying to find new deals. If someone has the exclusive rights, it kind of counteracts with anyone else's rights. So in addition to all these different compensation angles, there might be the ability to add additional financial incentives to these agreements. And obviously all of this should be agreed in writing, because that's how you're able to ensure that it's enforced, or at least more likely going to be enforced than not. So there could be performance bonuses. So winning a championship, winning a tournament, coming in second place, placing top 4, top 10. So it could be team or individual, winning an MVP, making an all-star team, or other kind of significant distinction, being the player of the match. There might be all these different bonuses applicable there. Sorry about that. The weather up here. So in addition to potential performance bonuses, some streamers and content creators might actually have bonuses related to different social media achievements and milestones. So there could be bonuses for reaching a certain follower threshold. So if you get 1 million followers on a certain platform or across all your platforms, you might get a bonus. If you have a certain number of content views, if you get 10,000 views on a certain post or any of these other agreed upon numbers, this could be included. Same as maybe streaming hour bonuses, the way to incentivize different streamers and content creators and players to stream more and be out there promoting themselves, their brand, making more content and promoting the team. There might be incentives and additional money for streaming more than was required. So these are all different financial opportunities that could be built into an agreement and are really important and help incentivize and reward, growth, where maybe they're not willing to spend as much on a salary, but if you, the talent, are willing to grow and put in the work and help build your numbers, they're willing to incentivize that and to, compensate you for that. And that helps them, because the larger you grow and the more gains you get, it only helps them by being associated and affiliated with you. So it's really important to kind of start getting creative with these things, because it's kind of a win-win for both sides, where you as a talent get, additional income, which is usually beneficial, and, the team or the organization or anyone else who's working with the talent gets additional exposure, additional notoriety, and this is kind of what they're hoping. So some teams and some organizations have a new trend where they're actually giving players sponsorship guarantees in their agreement, where they're actually saying that there's going to be a certain specific amount that the team is going to secure for the talent each year or during the term of the agreement. And if they don't secure it, then the team will cover the difference. So if it's a $10,000 sponsorship guarantee and the team only gets you $5,000 during the term, then they have to cover the other $5,000. So again, this is a way to give talent and streamers a little bit more incentives and a little bit more likely to maybe sign with an organization, because it's like, oh, well, they're going to get me all this other income. It might not be salary, but they're going to make sure that I get this. So it's really important to be aware that maybe there are these opportunities. So in addition, as we were kind of touching on milestones, it's important to be aware of how an agreement may terminate. So these are clauses that that address termination before the agreement or the term actually exists, and one after. So first, we're going to start by looking at termination before the actual agreement ends. So there could be the ability for a gamer to terminate an agreement early if they hit a certain milestone. If they get a certain amount of followers, it's like, okay, well, now this agreement, I can terminate it, and then we can renegotiate a new one, or I can find another opportunity, and kind of gives the talent the ability that once they hit a certain level, that they're not going to be locked into an agreement that might not necessarily fit them anymore, and that they'll be, potentially unhappy with as they continue. There might be the opportunity for what's called, a buyout. So having the buyout clause where a team can pay a certain amount of money to get you out of the agreement, to terminate it early, and someone could buy out your rights and you could be assigned to a new team. So the player themselves can do it, or a new team that's signing them could. As we mentioned, when you're getting signed to an organization, there are several obligations that you have on behalf of them. And these are all listed in the agreement. And again, they all differ based on the team, the game you play, the length of your deal, the amount of it. Obviously, the larger it is, the more obligations, the more things you might have to do on behalf of the team, and vice versa. If it's a much smaller, less intensive deal, then the amount might be less and deliverables might be less. So there are usually clauses addressing the number of streaming hours that a creator must handle during a month, as well as potentially listing which platform they must use, as there is a trend where many different esports organizations, not just the creators themselves, were entering into exclusive streaming deals with whether it's Twitch or Facebook Gaming or YouTube or any of these platforms. And as a result, their players and streamers would have to use that platform to stream. They couldn't use others, or they might have had to do a specific number on that streaming platform before they can do others. So again, this is all addressed in the agreement, and it's important to be aware that a streamer or content creator is usually required to stream a certain amount of hours, make a certain amount of posts a month or a year or a quarter, whatever it says, as well as utilize all of the team's sponsors on screen, not use any rival sponsors. Use their competitors' stuff is not permitted. Also, it's important when you're kind of doing these agreements to try to negotiate in some flexibility and a little bit of opportunity to maybe have reductions of these requirements depending on what else is going on. So there might be opportunities to get reduced streaming hours requirement if you're traveling or if you have other team mandated obligations. So it's important to be aware of, while there are certain restrictions and mandates, you should also try to see if there's some wiggle room or some potential reductions in these mandates if you're doing other stuff on the team, or if you're traveling to and from a foreign country and going to boot camps and tournaments, you just don't have the hours to stream as much as you can. This should be accommodating the agreement. They shouldn't be able to, reduce your salary or penalize you for this. So again, most of these agreements kind of impose restrictions on the gaming talent, the streamers, the competitive players, and the content creators, where they usually have to display the team's logo on their social media platforms and all their banners and all their streaming overlays, and really support the team, whether it's retweeting or liking all of their posts, engaging in somehow, retweeting and sharing their sponsors' content and posts, maybe doing on-air shout-outs for their sponsors, making sure they're using all of their sponsors' products on air and during streams and during any content that they create. So these restrictions are really important, because if you don't follow them, you don't adhere to them, you're kind of in breach of the agreement, which means they could, reduce or withhold your money or potentially drop you or worse. So it's really important as a creator to be aware of what your obligations are to a team and what you owe them and what you can and cannot do. So again, in addition to requiring the amount of streaming hours, many of the agreements may require the talent to participate in a certain amount of team and promotional marketing activations, and maybe a certain amount of content creation activations for them or their brand partners. So again, the number of promotional appearances per year or month, number of creating content pieces and what platforms, whether it's 2 YouTube videos a month, 3 Instagram posts, static, reels, all of these different metrics, all these different mediums are all addressed because they all have different values to different teams. And again, all this needs to be addressed in writing so that you as a creator know what you're supposed to do, what the team can ask you to do, and what's beyond the obligations, where it's like, oh, well, you're only allowed to have 3 posts a month. So if you want more, we could talk about that. And usually an agreement might say, if you go beyond this, this is the rate. Where it's like, okay, you're going to have 3 posts a week, but if you want 2 more, each post will be another $500 or another $200 or whatever the number is. So it's important to be aware that you want to have a restriction. You want to have this information in there so that you know what you're obligated to do and what you don't have to do. And once you kind of get to the ability to, okay, well, we've already done how many I'm supposed to do. And if you want me to do more, which I'm happy to do, you just have to compensate me. And if they don't want to compensate you, then the contract says you don't have to do it. And that's why it's important to have this stuff in there. So, in addition to these different requirements, another really important provision and one that's really of huge note is ones that address players' ability to be on the starting versus the non-starting roster. So there are many, obviously, with competitive players that are on multiplayer teams. They may have a starting roster and they may have a bench or substitutes in case, or they may have an academy team in addition to their, competitive major team. So again, an agreement must and should address how and under what circumstances a player can be moved to and from the starting roster, how that procedure works, and what happens. Certain agreements may reduce their salary if they're no longer starting. Obviously, if you're a player, that's not something that you would want. You don't want your salary to be reduced or cut in half if you're not starting. So you may want to try to negotiate and try to protect yourself from that aspect. So again, this is all stuff that's agreed in writing, but it's really important to be aware that usually the team has the right to, select who's going to be started and benched and on what terms. And many times they'll try to reduce a player's salary if they can, because if you're not in the starting lineup or if you're just kind of benched because we're going a different direction, that means we have to maybe pay other players more and other things. So it's really important to be aware of how this stuff applies. As we mentioned, there are many agreements, and as we see in the esports press, there are these buyout clauses, and some of them are usually pretty high. So it's important when you're negotiating a buyout provision in an agreement to be aware of what the number is and how it might be prohibitive or restrictive going forward. A buyout provision with a number that's too high might be really hard for another team to want to buy you out or move. So it's really important to be aware of this when you're negotiating an agreement, because everything's great until it's not. And to have flexibility to move to a different situation is really important. And if it's just too expensive and too cost prohibitive, it's probably not going to work out as you hoped. So yes, again, this is very important stuff, because if you don't address it and you don't look into it and you're not aware of it, you could really put yourself in a terrible position. It's really detrimental when you see a 6-figure or a really high buyout and it's like, well, I really don't think anyone's going to pay this amount for you, and you're not going to be able to pay it yourself usually. So usually you're kind of stuck in the contract until they decide they want to get rid of you, and chances are they're not just going to get rid of you if you still have some value. So as a player or a competitor, it's really important to be aware of how this might impact you, not only then, but in the long term and how you go. So in a similar vein, we have different clauses that address assignments and trades of a player, where usually a team has the sole right to assign or trade a player or to sell them to another team because they have the rights to the contract, and this might be something that they're entitled to. However, there may be opportunities for talent or gamers to have some kind of no trade restriction or some kind of approval over where they're being traded to, or having some say in it. While that's not always the case, and that might not necessarily be the norm, obviously with leverage and these different things, there might be these opportunities. It could be something as small as a geographic restriction, where if you're a North America-based player, you could have a restriction where you can't be traded to, another country or another continent without your approval. Or there might be certain restriction teams that you might not go to because you've had bad experiences there, or you don't like the people in charge, or whatever other reasons. So there's a lot of different limitations that might be able to be negotiated for from a talent or a gamer perspective. And it's really important to be aware of this, where you might not get a full no trade clause where you have the ability to approve and reject anything and it's in your sole um, wheelhouse and that you're the arbitrator of it as a talent. But you might have some sort of limitation where it's like, okay, well, if you're going to send me to something that's within these parameters, I need to approve it or it doesn't happen. So if you're going to send me to China or to Korea or to, Paris or Berlin or some other country that, I'm not from there, I know the language, I'm going to be alone, that's not something I'm going to do. Maybe you have the ability to, restrict it or veto that trade. So again, it's not a full no trade clause, but it still has some restriction, gives you as a talent or player some protection and some ability to kind of mold your own path a little bit. Or if they want you to waive that no trade clause and they really want to trade you to China, then you have to get paid for it. It's like, okay, well, you got to pay me double if you're going to trade me to, the Shanghai-based team from the Texas-based team. So these are all contractual things that if you didn't build them in, you didn't try to adhere to, you kind of just won't have that ability. You won't have that right, and you definitely won't be in the position to do it. So we kind of started looking at how an agreement may terminate early. Now we're going to look at how it may terminate when the term ends. So when the initial term and maybe how many options are existing when the contract's about to end. Many agreements have what are called a right of first negotiation or called a right of first offer. So what this means is a right of first negotiation provides the party that has this right with the right to decide whether they want to extend the agreement or not. It gives the team or the player the ability to exclusively negotiate with their current team to extend and continue playing there. Usually these, contract renewal discussions are required to be done in the last 60 days or the last 90 days of an agreement or last 30 days of an agreement as their, agreement's coming towards an end. And this is really important because if there is this right of first offer or right of first negotiation, this means that assigned talent must first negotiate or try to negotiate a deal with their existing team or organization before they're allowed to engage or talk to any others or field any other offers. Usually there's a time limit where this exclusive negotiation might be a 30-day or 60-day period. And if the parties cannot agree on a new deal, then the talent now has the right to explore other offers. But again, it's really important to know that if a player starts talking to other teams during this time period, this exclusivity period, they can be seen as breach of their agreement, to not act in good faith, and kind of put them in a really terrible position where they're kind of now liable for a breach of contract and start a whole issue, especially if they're going to go to another team and this team doesn't want that to happen. So again, the time period that's prescribed, whether it's 30 days, 15 days, 45, or whatever number, is really important because the longer it is, the less opportunity you might have to find another team or the less options that might be. So this is a really important thing for all talent to be aware of, that as their agreement ends through natural termination, not a buyout or retirement or being dropped or benched or anything that ends before it naturally expires, there might be this right of first negotiation where you have to first negotiate with the existing team before you can field any other offers, before you can talk to other teams. And depending on when this, the contract starts, when the time period happens, you might fall out of the free agency period. You might only be there for the last, 2 weeks of it. So This is a really important thing to be aware of and to address and to make sure you fully understand it, especially if you don't want to re-sign or you want to explore your other options or you feel like the original deal that you had isn't, in your best interest anymore, or you want to see what another team has to offer. But again, if you under this exclusivity period, you can't. And if you do, you could really, put yourself in a pretty bad position. So, in addition to a right of first negotiation, many agreements have what's called a right of first refusal or a matching right. So, what this means is that if after the first negotiation period we're not able to come to an agreement, the player and the team, and the player goes out and finds another team that's willing to sign him, if the first team has what's called a right of first refusal or a matching right, that means the first team has the right to match whatever that new player is offered from the new team. And if this team matches it, the old team, then the player has to stay there on those terms. So, to give an example, let's just say you're a Call of Duty player and you're signed to FaZe Clan and you try to renegotiate and nothing happens. And then you go to Team Liquid and they offer you a deal. So then, if there's a right of first refusal that the original team FaZe Clan has, you have to go back to FaZe Clan and now present the deal that you were offered from Team Liquid and be like, hey, FaZe Clan, do you want to match this deal or give me a better deal? And if FaZe Clan says yes, we'll match or give you a better deal. Then if there is a right of first refusal, then you have to stay with FaZe Clan and you can't go to the new team. You can't go to Team Liquid. However, if FaZe Clan decides not to match it or only wants to give you less, you're not obligated to stay there and you can go with the Team Liquid offer. But it's important that you can only accept the same terms and conditions as the offer presented to FaZe Clan. So if you go back to Team Liquid and they're like, oh, well, now we're going to offer you less because you took so long, you can't accept less. You have to first go back to FaZe Clan, who then has the right to match that. And if they don't match, then you can go to Team Liquid. So again, this is a really important thing to be aware of, whether this exists and how it functions, where you may not have came to an agreement during your exclusivity period. However, if you then find another team and the team knows, okay, well, someone else is willing to pay this, so if I want you, I have to pay this, it gives them the ability to do that. And that's what's called a right of first refusal or a matching right. Again, these are two very common things that are in most agreements and give the team the ability to work with a player they've worked with for a few years, maybe started at a certain level and now has grown under them. So these are really common, and it's just important to understand how they work and how they affect a talent or an individual's ability to go forward in their career and what it means. Again, there's nothing inherently wrong with it, but you have to make sure that you adhere to it and follow the directions and follow the different time limits because it'll have an impact. Perfect. Okay, so as we kind of move towards the last stretch of the lecture, we're going to look at name, image, and likeness, NIL. So, again, many agreements with professional organizations in the esports and video game space have clauses that address the use of a talent's name, image, and likeness rights and how the team can use it when they're signed to the team as well as when they're no longer signed to the team. So to kind of start, name, image, and likeness is this concept that the Constitution provides each individual or celebrity with the right of publicity, which provides a pro gamer, a streamer, or content creator with the right to profit or to license their likeness to another party for compensation, which means that a party cannot use another celebrity or known entity's name, image, or likeness without their permission or without compensation. So name, image, and likeness refers to the actual full name, their legal name, their gamer tag, any photographs of them, any logos, any biographical information, their signature, their voice, any audio or video files, anything that represents them, any catchphrases, anything they're known for, whether it's different items or different kind of vernacular nicknames, all of these different things that are associated with this individual talent, not just their name, not just their, gamer tag. It's the whole, breadth of what they are, whether it's their logo, whether it's their catchphrase, whether it's their motto, any of these things that are readily identifiable with them is protected and would be considered in this name, image, and likeness bundle of rights. Generally, under many of these agreements, the team has the right to utilize and compensate and license any of their players' name, image, and likeness. Generally, it's appropriate to try to limit that to a non-exclusive ability where the team doesn't necessarily need the exclusive rights to a player's name, image, and likeness, but sometimes they insist on it. Sometimes they feel that they want to control every use that's not related to them because they need to. So again, it's really important to be aware of how a team can use and restrict a gamer's actual use of their own name, image, and likeness. Generally, it should be okay for it to be a non-exclusive use because that doesn't inherently prevent the team from doing what they need. Whereas they may use a gamer tag or a gamer's face or image or even their signature on any, team promotions, team items, sponsored content with their brands, any team, decks or websites, any of their other messagery. So as a result of these agreements, the teams are granted the right to do this and to essentially use their talent's name, image, and likeness, their NIL rights for profit. And it's usually given the right where they might have the right to this compensation or the right to do this during the term of the agreement. So when they're signed to the team, so as potentially when they're no longer on the team, which is obviously a very important matter to address and to be aware of and how that happens. Where usually during the term, the team will probably have the exclusive right to use it for any purpose, commercial, non-commercial, promotional, marketing, any other use. However, when you're no longer on the team as a talent, you might want to restrict or change those uses where they no longer can be blasting ads featuring you and their team and, having you in their newsletter blast saying, click me to get my jersey. So there might be different restrictions on your name, image, and likeness usage when you're no longer on the team, when you're no longer signed to that organization, and maybe you're on a new one. So there might be restrictions that the team can only use your name, image, and likeness for archival and promotional purposes or non-promotional purposes or no use at all, that once you're no longer with them, you can't be featured there. You're not there. Or maybe they can only use it for a certain time period where it's like, okay, 6 months after the agreement, you can use it, but then after that, it's done. So again, these are really important restrictions because if someone else is using your name, image, and likeness, it's really hard for another team to then be doing it, or another brand or another company. So being able to, as a creator, as a streamer, as a professional gamer, you have to be aware of how you want to manage this, how it's going to affect your other abilities to monetize and license yourself if another team or another organization has certain rights to it and what those apply to and how long those are for. So again, this is a really important concept and something that, gaming talent need to be aware of because it could severely impact your ability to go to another team or to work with another brand. Because if you're signed to Pepsi or Coke and signed to Pepsi, there's all these ads of you, it's going to be really hard for Coke to then want to pay you if Pepsi can still use your image or the team can still, sell jerseys with your name on it or sell, posters with your face on it when you're on another team and they're trying to sell posters with your face on it or jerseys with your name on it. So again, these are really important things to be aware of because they can really impact how a creator moves forward in their career and the amount of money they can or cannot earn. So, additionally, many agreements address the actual IP rights and the creations by the talent that are signed to the team, where generally the team is the owner of all of their creations, all the video, all of the things that the team gets and that you create for them. Where generally you as a player are assigning all your rights to it, and everything's considered a work for hire on behalf of the team, where they're paying you X compensation in exchange for these deliverables, in exchange for your rights in this stuff. So again, it's really important that when a gamer is hired to create a TikTok video or any other kind of item, they might not own it, and it might be owned by the team or the organization that they're creating it for. So again, some agreements might have non-compete clauses in them, which might apply to what brands or what certain categories a gaming town or creator might be able to work in and when they can. So these are really important clauses to be aware of as individuals go forward and as they work with different companies and brands, because if your non-compete says you can't do work in a certain category for a certain amount of time, this could really impair your ability. So as a result, you should be aware of this and what these restrictions are and everything related to that. So as I mentioned, many of these professional video gaming agreements are 20, 30 or more pages. So these clauses were not meant to be a full interpretation, a full, use this and you know what's in an agreement. It's meant to just highlight some really important points that you should be aware of when you're signing these agreements, when you're understanding what you should be focusing on. And if you're an attorney or professional working in this field, these are the kind of things that you should be looking at that are going to have real practical implications on your talent or your client. And if you're a talent or a creator, you should be really aware of these different things and how they might affect your ability to grow in your career, move to a new team, work with a new brand, work with a new company. All of these things are all based on, existing agreements and what it says. So again, every agreement is different. You should really consult an attorney specializing in this field to really understand what's applicable to your situation, because everyone is different. Every agreement is different. It's not like traditional sports where you have the NFLPA and the NBAPA, and they have these standard collectively bargained agreements that every talent signs. And the only thing that really changes is the compensation. Whereas in esports and the competitive gaming scene, whether it's creators, content creators, or League of Legends, Valorant, Call of Duty, all of these have different agreements, different teams have different agreements, different leagues have different agreements, different countries and teams in different countries have different agreements. So it's really important to just be aware of that. So to kind of bring this all to the end, as many of us are aware, the NCAA had changed their stance on student athletes' ability to earn income and profit from their name, image, and likeness rights, which we kind of just touched on. This ruling has really provided a lot of clarity and guidance for competitive gamers and streamers and content creators who might be looking at going to college or competing in college esports or college athletics, being a college football player and also being a streamer or content creator. The ability and now the clarification and this interim policy set by the NCAA based on the different lawsuits and state legislation has really kind of paved the way for content creators and streamers to be involved in collegiate sports, be involved in, collegiate esports, and be a campus influencer while also being an athlete, a student athlete at the same time, and earning an education while earning income through your name, image, and likeness. So it's really exciting that, college gamers now have the ability to earn income for coaching or doing gaming sessions or events or autograph signings or meet and greets or live appearances or, paid speaking events or even going to alumni fundraiser and networking events and being able to be this gamer, streamer, creator, influencer in this world. They're also able to earn income the way any other influencer does, from social media, from TikTok, from Cameo, from Twitch, be a streamer, where as a college athlete or a college student, you no longer had to potentially worry about this being an avenue that might impact your eligibility. Again, if you're a competitive gamer and you're signed to a team getting a salary and earning income from tournaments and from sponsors and these different platforms, that we talked about, merchandise, digital merchandise, physical merchandise, you might have had to worry about losing your eligibility if you also were a student athlete or there were on, a college scholarship, where now this is no longer a problem. So I think that it's really exciting to see how, even though the NCAA isn't really regulating college esports, as I'm sure all of us know, they've kind of made this path, paved the way where if you're a competitive gamer or a streamer or content creator and you want to go to college and you also want to compete in athletics, or you also want to be involved in, the college campus another way, it's not going to be impacted. You don't have to stop streaming or, no longer play competitive games or no longer be signed to a team or no longer have a GFlu code or any of that other stuff. So I think that's really promising, and I'm sure we'll see an influx of more competitive gamers that are going to want to go to college and or maybe are also athletes and want to have the collegiate experience, play football, but also be a pro gamer. And so there's going to be a lot of amazing things coming up. So I'm really excited for where that goes. So thank you everybody for tuning in. This was great. And, if you have any questions, please reach out to me. Check out my website, jmjesq.com. Follow me on Twitter, JustinJESQ. Make sure to check out my book, The Essential Guide to the Business and Law of Esports and Professional Video Gaming, which is available on Amazon and Routledge and Barnes & Noble and everywhere else. #ad. So please, my DMs are open. Please connect with me on LinkedIn or send me an email. I really love to be, impart wisdom and be a useful vehicle for everyone. So in the last few minutes, we'll open it up to any questions. And thank you again for having me, everyone out there, and for listening. I hope you learned some useful stuff. Yes, I would love to answer any questions. So first question is, what do you think are some red flags you would look for when entering into a contract? I think my kind of philosophy, especially on negotiation, even before you enter into an agreement, I think that if they're like not willing to negotiate on anything, or there's kind of like a take it or leave it deal, that to me is a huge red flag, because the point of negotiation is that it's not take it or leave it, that we're going to negotiate and come to reasonable accommodations. And yeah, you might not get everything, but you shouldn't be like you're not getting anything. But in terms of stuff that I think are just kind of non-starters, if a team, makes you reimburse them for your tournament or lodging for expenses. I've seen agreements where a team, if you win, is going to take out your airplane and hotel from your tournament winnings. And like, to me, that's kind of disingenuous and kind of against the heart of this notion. So if I see something like that, or something that's very predatory, or something where they can drop you whenever and you don't have the ability to drop them, these are some really big red flags and things that you should be aware of. Again, a really high buyout, something that's like, $250,000, $500,000, some obscene amount for a player who that really has no relation, that could be another thing to look out for, because it just might be something where it's like, why would they value this agreement or this player at this? It doesn't make sense. So I think ultimately understanding why they're putting something in there and what their motive is. And, you also don't want something that, you're not getting paid to do anything, or you have to cover your own expense. So like, it's really important to make sure that you feel confident with the agreement. So question was, is it common for a team to take part of their talent streams and other revenue sources? Well, yeah, as we mentioned earlier in the lecture, generally a team will, get a cut of tournament winnings for any competitive players. They may get a cut of, advertising and streaming revenues. However, I'm pretty adamantly against that from a talent side. I think that that's just kind of money that the talent should really get. But sometimes if they're paying you a lot of money and, you're not competing, there's no way to really earn income off you, they may want a cut of that. Additionally, you might get income from different sponsors, and the company, the team that you're signed to might take a percentage of that, or they might just limit it to deals that they bring you, where, they get you a $20,000 sponsorship deal and they take 10 or 20% of it and you get the rest. So these might be ways that an organization is earning income off the player beyond, what they're paying you. Again, we've seen teams that will try to recoup, a really large, sizable amount of tournament winnings, up to almost 50%, which is, that might be a red flag in itself, that like a team's going to take half of your tournament winnings. It's like, what's the point of winning? No, but you really want to win. That's a joke.
Hey, Justin, one question here. You mentioned at the end how the ruling sort of eliminated a lot of ambiguity around this. Is there any ambiguity remaining? Yet still to be decided?
I think that we see there's some pending litigation against the NCAA because, for anyone that's following the evolution of the NIL in the NCAA world, is that some colleges started to put restrictions on the brands that they could use. You can't use competitors' brands. You can't, if we're a Coke school, you can't do an ad drinking Pepsi on campus. If we're Nike, you can't wear Adidas during team practice. So you start to see different schools putting limitations and restrictions on the ability, and players being like, well, you don't have this right, like I'm a free, like maybe there's certain categories that maybe you don't want me to do. In some schools have outlawed tobacco and liquor and some underage kind of things, gambling, etc. But do they even have the right to do this? If you're 21 years old, like, you're entitled to drink. Should they permit you from having Coors Light sponsorship? It's a very interesting situation. So I do think that it's still trying to figure itself out. But in terms of being, the star quarterback for a team and then being signed to Team Liquid, like, that's a home run. So I think that eventually we're going to see that as evolution because we know how influential college market is and how they college students really influence all avenues of society, especially in this pop culture world that we're in. So being, this super influential sports figure as well as this big streamer content creator, I think is going to be, a really valuable commodity asset for any team, organization, or for any school, being able to have someone that can really transcend all these different markets. So previously you would never be able to have that at all, where, the Jeremy Bloom decision made it very apparent that if you're a professional skier, an Olympic skier, you cannot be a college athlete. If someone is going to sponsor you on something totally unrelated to sports, you are now ineligible. However, that's not the case anymore. So I think it's still kind of figure itself out, but ultimately the path is a lot, safer than it ever was.
Awesome, thank you. Are there any other questions? Okay. Well, Justin, I will make sure that you get a copy of this recording. Thank you so much for joining us. I know you put your contact info in the chat already, correct?
Yep. So, like I said, jmjesq.com. It has all my social media links and my email and, links to check out the book. So please, check it out, especially if you're interested on any of this. It really goes into this stuff in a lot more detail, explores a lot more contract clauses. So thanks again for having me, for tuning in, and enjoy the rest of the conference.
All right. Sounds good. Thank you, Justin. Thank you all.